part one of the Insider exclusive TV documentary on the U.S. Army Corps of Engineers Mr. Go disaster. John Andre and Gilbert Andre discuss the entire history of the Mississippi River Gulf outlet Mr. Go litigation against the U.S. Army Corps of Engineers, going as far back to Hurricane Betsy in 1965 and the Gracie case, and how the firm has successfully fought for the people of Louisiana against the U.S. Army Corps of Engineers, obtaining an amazing verdict for the people. In this second and final segment of the show, they now share some additional insights on the legal battles and the issues that lay ahead of them, as well as offer sound suggestions for the future of the Mr. Go ecosystem, such as restoring the Mississippi River Gulf outlet area ecosystem that was severely degraded by the now deauthorized and blocked off Mr. Go ship channel. This is of great importance to local communities and environmental organizations working on coastal Louisiana restoration. Also, by doing whatever needs to be done to restore the wetlands, and making sure that the restoration of the wetlands will require a combination of techniques that build land and reestablish the natural salinity and flow of water and protect shorelines. Will this cost a lot of money to close the Mr. Go and restore the wetlands? It will, but the cost pales next to the multi-billion-dollar risk that the greater New Orleans area and St. Bernard Parish face as long as wetlands decimated by Mr. Go are not restored. If we follow the advice of some of the world's most renowned experts and scientists who recommended several priority projects for the Mr. Go ecosystem, like mitigating many historical impacts of Mr. Go channel, increasing protection from hurricane winds, waves, or storm surges, improving fish and wildlife habitat, and increasing the resiliency of the coastal wetlands to erosion, subsidence, and sea level rise, then we've got a fighting chance at saving and preserving one of America's greatest environmental treasures. Today, the Insider Exclusive brings you part two of its two-part special U.S. Army Corps of Engineers Mr. Go disaster, to see how John Andre of the Andre Law Firm is taking the baton from his father, Gilbert Andre, and continuing the legal battle on behalf of the people of New Orleans in the Katrina Canal Breaches Consolidated litigation. Both of them will share some of their thoughts on the lessons learned in this true David and Goliath battle, as well as their thoughts on restoring the Mr. Go ecosystem. John Andre and Gilbert Andre have earned the highest respect from citizens and lawyers alike as some of the best trial lawyers in New Orleans, in Louisiana, and in the nation. They are driven to fight for people who have been harmed by willful and negligent actions of others. Their goals, not only to get justice for their clients, but to make sure that all Americans have the right to justice, because injustice anywhere is a threat to justice everywhere. Hi, I'm Steve Murphy, and this is the Insider Exclusive, live from New Orleans at the Andre Law Group. We're back. We're going to be discussing the Robinson versus U.S. case. I have with me John Andre and Gilbert Andre. Welcome to the show again.
Hello.
We're going to discuss this Robinson case, which leads into this huge, based on your case, huge issue of the Mr. Go project. So why don't you start out, John, since you are one of the lead counsels, and this was your case, actually, Robinson versus U.S. Please tell.
Robinson began when I was heading back to New Orleans for the first time after Katrina. I left my family in Faraday, Louisiana. And on the way back, I called Dad and others to see kind of where they were and what was going on, because we didn't have any contact with anybody. So I bought a cell phone out of Mississippi because you couldn't get the New Orleans ones to work. I called Dad and said, this is Gracie 2 all over again. That shouldn't happen in an American city. I mean, St. Bernard was gone.
And for our audience, when you say this is Gracie 2 all over.
He did the Gracie case, which
Yes.
was Gracie versus the United States, involving the flooding from the Mississippi River Gulf outlet.
Which showed that the U.S. Army Corps of Engineers was responsible and was liable, right?
Right, that they knew that it could and would conduct storm surge into the city of New Orleans.
Okay.
And he said, yeah, you ought to file a suit. Somebody should address it. And then I came back to the city and began talking with people and ran into numerous people, thousands of people, who were interested in filing a suit against the Corps because everything that they had was gone. And when you come back to New Orleans, or when you see videos of New Orleans, because a lot of people couldn't come back immediately, and they were just looking at Google Earth and seeing their house flooded.
Right.
And it's one of those dynamics that when you have everything you own gone, that's a very traumatic event no matter how old you are. Well, when I came back, what we did was you couldn't really talk to anybody. And so in trying to reach out to people who were members of the community that had issues or were coming back cleaning their house, I went in and put together signs that I had printed, and then we went and they're similar to like modern day election signs, and and we put these up all over. So
because the cell phones didn't work.
Cell phones didn't work. Phones really didn't work.
Right.
The majority of the people that we talked to via email, and we received thousands of emails in a very, very short period of time. We filed the Robinson notice on October 24th of 2005. Prior to suing the Corps of Engineers, you have to file a notice with the Corps to put the offending agency on notice of your intent to file the suit.
It's like serving them.
It's like, well, it's not like serving them.
Yeah.
What you have to do is you have to file notice, and then they have 6 months from the time of the notice in an effort to settle the case. That provision was put in the Federal Tort Claims Act in an effort to try and get agencies to settle cases prior to the time they wound up in the judicial system.
And what did they do in that?
And they did nothing. They just sat on it for 6 months. And there have been documents created, accounting reports for the Army, wherein in footnotes the Army said all of these notices have been filed against us and we don't intend to do anything with them. And then we waited 6 months after filing the notice in Robinson, and on April 25th of 2006, 6 months to the day, we filed the case of Norman Robinson versus the United States, which was 6 plaintiffs against the Corps of Engineers.
Right.
In the case, we drew Judge Duvall, who at the time was overseeing the Katrina hurricane litigation.
And there's something interesting about this judge. He really cares about the right thing to do here.
Right. Judge Duvall was an exceptional draw for both sides because he was a very engaged and an extremely intelligent judge who took his job very seriously. This case involved 10 million pages of discovery that was produced that we went through. We filed expert reports that were 2,500 pages long. Right. Judge Duvall, we had thousands of pages of exhibits at the trial. Judge Duvall read all of those prior to the trial. He held our feet to the fire throughout in arguments on issues such as discretionary function immunity, which was denied prior to trial and then based on the evidence at the trial. Judge Duvall quoted footnotes to the lawyers. And so he was a very good draw because he did exactly what we would want a federal judge to do.
Let's talk about some of these legal issues and the defense claims to them, okay? You brought up discretionary function immunity. What is that for
Discretionary function immunity is immunity for executive branch decisions of the government that have policy considerations and are based on policy considerations.
Yeah.
So that you don't have effectively judicial second guessing of decisions by the executive branch. In our case, Judge Duvall found that the decision by the Corps of Engineers to build a channel and to locate it in a particular location is a discretionary function based on an economic policy for shipping. However, he also found that once you build it, you have to maintain it properly, and you have to use due care in the maintaining of it so that it doesn't injure people.
So building it, you have immunity, but maintaining it, you don't.
Correct.
So that's really the key here.
That's correct.
Yeah.
Correct. And it's based on, there's a case called Indian towing, which was rendered by the United States Supreme Court. And that involved barges in an island where there was a lighthouse. And the barges, Indian towing was the name of the tug, pushed the barges and sunk the barges, and they sued the Corps of Engineers for not maintaining the lighthouse.
Okay.
And the Supreme Court effectively found if you build the lighthouse, you have to keep the light on. And if you build a shipping channel, you have to keep the light on. And then the other immunity is the 702C immunity, which, based on my dad's case, Gracie versus the United States, our theory of negligence was not that the structures along the Mississippi River Gulf outlet, which were purportedly levees, were bad. We in fact said they performed exactly as they were designed.
Yeah.
Our theory was it's the same as a Coast Guard cutter or a Navy ship that was driving down the river where the ship captain fell asleep and the ship ran through the levee. Essentially that the negligence wasn't the flood control structure, but the negligence was something else, and that is the failure to maintain the channel properly is what caused the flooding.
Right.
And so the Corps, to this day, we won before the trial court. The trial court found that the Corps was monumentally negligent, that they were malfeasant, that they were non-feasant, and the Corps is now appealing that decision based on their immunities or their perceived immunities to the U.S. Fifth Circuit.
In other words, we're kind of ignoring what the judge said.
Correct.
Yeah. Now, you won this one last year, October?
Yes, it was November of 2009.
2009. And so it's been in the appeals court for
about a year.
About a year.
Mm-hmm.
What do you see, what is your guesstimate, both of you, that the appeals court might do with this case?
My guesstimate is based on the law and evidence. I think we should win the immunity arguments.
Okay.
I think Judge Duvall wrote a very good decision, made very good factual findings, and well-supported factual findings. I say very good, not because we won, but very good because he made a decision based on the evidence, and that's what federal judges do every day. And his decision was based on, at the trial, the Corps came in and they moved the track of the storm and the peak storm surge in an effort to get their evidence and their water models to work. Their lead expert was a man named Bruce Ebersol. Judge Duvall, in his decision, found that Mr. Ebersol prevaricated, and that is that he just made stuff up as he went along.
A better word is lied, right?
Correct.
Yeah, that's
Correct.
a perfect word.
That's a perfect word.
You have a word a lot of people might be familiar with. Now, hopefully, your decision will be upheld.
Correct.
All the way,
Yes.
maybe if it goes all the way to the Supreme Court. And if as a result of that, then what happen? What are you doing after that?
Well, based on in normal cases,
Yeah.
they have principles of law called res judicata or
Right.
collateral estoppel, and that is once an issue is decided, it can't be relitigated.
Right.
The Corps of Engineers maintains the position that the Corps is not subject to those provisions.
How could that not be?
Well, it cites a case called U.S. versus Mendoza, and it says in that case that the United States is not susceptible to principles of res judicata and collateral estoppel.
So saying I'm not subject to the rules.
Right, and they say that they get to come back and relitigate all of the issues over again.
You have what, in excess of how many cases?
About 3,000.
3,000 cases are all based on the same principle.
All based on the same. When we also file class actions, and those class actions cover everybody that was involved and who was living in St. Bernard Parish in New Orleans East and the 9th Ward at the time of the storm.
Right.
That's about 180,000 people.
Right.
We have to remember, a lot of us have forgotten Katrina. Katrina was we call the greatest diaspora in American history. They moved 700,000 people out of the city of New Orleans in a day and a half or 2 days. A lot of those people haven't come back.
Right.
Clearly what happened here should not have ever happened in an American city.
One thing to remember too is that this isn't something that took the federal government by surprise.
Right.
You remember that Betsy happened in '65, and now we're talking about 2005. 40 years. Now, in that time, science came a long, long way, and the Corps of Engineers did nothing. In effect, they did nothing. They did nothing to solve the problem.
Judge Duvall
in 40 years.
Found that they not only did nothing, but they made it worse. What we would like to hope would happen if the Fifth Circuit rules in our favor, or even if they don't. There was the Grand Teton Dam failure in the United States in 1974. It was built by the Corps of Engineers and it predictably failed. Gerald Ford, through executive order, asked Congress to pass the Grand Teton Victims Relief Act, where all of the victims of the Grand Teton Dam failure were compensated for their losses. And we would hope, and have been asking for years now, that Congress and or the administration order Congress to have a victims relief fund for Hurricane Katrina, because Katrina wasn't a natural disaster in New Orleans. It was a man-made disaster. The storm had passed when all of the flooding occurred.
You know, with any kind of legal cases, hopefully, this is one of the reasons why lawyers pursue cases like this, there is changes that are implemented. What kind of changes do you see happening as a result of the acknowledgement by the government that the ecosystem that has been destroyed, basically, by MRGO? What kind of program do you see in restoring the ecosystem?
We filed Robinson, and we also filed a case called Savoy versus the United States, where we asked for an injunction with a federal judge ordering the Corps of Engineers to adopt a remediation plan, and then to ultimately close the Gulf outlet. We've already effectuated those changes, and we've already had that. They had a rock dam that was in place, closing the Gulf outlet, that was put in last year. They've also put in a barrier, which is a storm surge barrier at the funnel, which is where the Mississippi River Gulf outlet turns to the south, and Lake Bourne is situated, where a lot of the storm surge came from in the Katrina event. So those changes will help to restore that marsh area and the natural buffer area for the city of New Orleans. We'll probably have to have more accelerated, like pumping in dredged material and those types of things, so that you can then effectively build the land back to what it once was.
And this is something that really has to be done, isn't it?
Well, it does, but like I have a photograph of what it was before the Gulf outlet.
And that was 1927?
Now this was 1958.
1958.
In 1958, which you see is the ceremonial first explosion of the Mississippi River Gulf outlet. When you look at this is actually land back here. This is not a canal or water, it is a cypress forest, and it's land.
And talk about cypress trees and their roots for a second.
Cypress trees are the greatest storm, it's the greatest resistance to what we call storm throw that there is, as far as a natural barrier, because a cypress tree has a root that remains close to the surface. So as a result, when it gets hit by water, it's like a T-wall, and the tree is balanced by the root system, so it slows down the storm surge to such a degree that you never had flooding of New Orleans, other than after the Gulf outlet was built.
Right, and when they destroyed that web. It's a nice web.
Right. What they had was, in that area you had interlaced canals. That in over time, when the canal floods, it creates a ridge, and you had interlaced ridges that held the fresh water in and prohibited the salt water from coming in. And they cut the channel directly through those ridges, which then allowed the salt water to come in unimpeded, which effectively killed the whole cypress swamp.
Well, let's hope, as a result of your case, and the Fifth Circuit sees it your way, and let's hope you're successful in this, and let's hope for the long run, for the people of Louisiana, and for the people of the United States, that the right thing is done here, and the entire Mississippi River Gulf area is restored in its natural habitat. I want to thank both of you for being on the program.
Thank you.
Thank you.
We'd love to have you back again. Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.